Let's come back from the lunch break, please. We're back after a lunch break, and it's time to begin the questioning of Mr. Wrinkle. Mr. Cloutier, will you be, or Ms. Tripp?
Madam Hearing Officer, I'll be cross-examining Mr. Wrinkle.
Thank you.
Ms. Tripp,
Go ahead.
may I take up a preliminary matter before? Thank you. Madam Hearing Officer, I have a request of the commission, kind of depending how the rest of the afternoon plays out. And I have checked with the other parties. We're all in agreement to this approach. Of course, we leave it to the commission's sound discretion. But in the event, Mr. Powell, who will have a lot of testimony and a lot of cross, has not taken the stand by the time 4 o'clock rolls around, public comment. We've all agreed, if the commission agrees, to start that Monday morning and make that request of the commission, depending how things play out. Just wanted to bring that to y'all's attention at the earliest time we could.
All right, I'll wait to answer until we have the chair in hand.
Thank you.
All right, thank you. Go ahead, Ms. Tripp.
Thank you, Madam Hearing Officer. Mr. Wrinkle, this is Ann Tripp, and I'm an attorney with IP&M. Can you hear me okay?
Yes, I can.
Okay, great. Well, first, thank you for being here and coming back after the lunch break. I can understand Friday afternoon. You probably have other places you want to be. But I wanted to ask you a little bit about some areas that we didn't necessarily cover on direct, because it sounds like the testimony you're offering comes from your past experience. Is that a fair summary or a fair characterization? Okay.
Right.
So actually, I'll flip that. I'll switch it on you. Could you explain what it is you do with the Oil Conservation Division in your role now?
Sure. I'm the engineering bureau chief. I oversee a group that's admin permitting. So that group consists of 8 or 9 folks that do all the permitting for oil and gas wells in the state that has to do with hydrocarbons, drilling, cement, that kind of stuff. The UIC group, which underground injection control. So, underground injection control. And I have 3 to 4 people in that group that handle all underground injection. Then I have special projects, which is special projects engineering, which mainly handles all the OCD hearings. And then you heard from Mr. Garcia earlier, is the operational side of this program of plugging the wells. And then also we recently onboarded an individual to take on our Class 6 if we receive primacy from the EPA. And then all of the boots on the ground inspection folks in the state under engineering are underneath me.
And can you expand a little bit about what's the reference to Class 6 primacy?
Yeah, so we're applying with EPA to have primacy like we do on our Class 2 wells for carbon sequestration wells.
And that's still pending before the EPA, is that right?
Yes.
Thank you. And in terms of special projects, you mentioned special projects includes the operational side of plugging wells, is that right?
Yes.
And how big is your team that works on those issues?
Just for the plugging on the special projects?
Yes, sir.
3.
Okay, thank you. And so now I'll go way back in time. I have your CV, which was submitted as an exhibit, but it doesn't refer to your educational background. Do you mind touching on that briefly, please?
Yeah, no, I have a high school degree.
And where'd you graduate from high school?
Well, I got my GED from Eastern New Mexico University when I was 16.
And where did you grow up?
Roswell, New Mexico.
And so on your resume, it looks like the first oil and gas position is related to Rock Resources and McKay Oil. Is that right?
Yes.
Okay. And so approximately Sorry, I can't do the math in my head so quickly, but about what age were you in February 2003?
I was in my 20s. I
Okay.
can't do the math either that quick.
No, that's all right. And so what led to your transition from the investigations group to work for Rock Resources or McKay Oil?
Well, that's a little private, but if you must know.
You're testifying based on your experience, and I'm trying to understand how you got your start in oil and gas and the breadth of your experience there.
Okay,
But
no.
we don't need to know. That's fine. So the work with Rock Resources and McKay Oil, how would you describe that operator?
Well, it was a smaller natural gas operator. They didn't have any oil wells. They had, a few hundred wells in the Abo field that they pushed into the El Paso pipeline. Very shoestring budget, smaller operator. Good folks.
So it's not your opinion that Rock Resources or McKay Oil was a bad actor or a imprudent or irresponsible operator?
No, not my opinion at all.
And so from there, and just to be clear, on that portfolio, you mentioned some shallow gas wells. Do you consider all those wells marginal?
At the time, I can't recall the actual production of each one of those, but yes, those wells would be considered marginal.
And what definition are you using for marginal?
Well, you have two separate sets, right? Under 90 BOE is going to be non-beneficial, and then you have 90 to 1,000, which is marginal.
And so you're applying the parameters that are proposed in the rule change of 1,000 BOE and 180 days production to define marginal wells?
Correct.
And it was those parameters that were used throughout your testimony when you refer to economic analysis of marginal wells.
Yeah, to the best of my knowledge, right? Like, there may be some times that I remembered, that it could be a little bit outside of that, maybe a little below that. But they were pretty clear cut. Either there was no in between really that we had. It was either, really good producing wells or very low producing wells.
And you're referring to those 7 years with Rock Resources and McKay Oil, or are you referring to over your entire career?
Entire
Career. Okay. Thank
yes.
you. And so from there, you moved on to, I believe, Marathon was the next oil and gas company that you worked for?
No, in between there, I did some flowback contract pumping for a little while for mobile data that was in North Dakota.
Okay, North Dakota, thank you. Are you relying on any part of that experience in your testimony that was submitted for this rulemaking?
North Dakota, I couldn't because the Bakken is a fairly new play, and those were all new horizontal wells. So and also when I was in North Dakota during that time, I was not a decision maker. So it's based upon when I was in New Mexico, basically, just for the main fact that these were the wells that are defined or at. There wasn't any in North Dakota.
So jumping back for a second with McKay Oil, were you a decision maker there as a lead field operator?
A decision for route changes, where one goes. I would make recommendations for repairs, that type of stuff. But I never really held the final decision on things. That would have been my superior.
And is there a certain position or title that that decision making rested with? Is it a production supervisor or a different person within the company?
I believe there it would be the equivalent, and I think his working title, it's been so many years, was field foreman. I think he was over the entire field.
And about how many employees did McKay Oil have at that time? And I'm sure it varied, so just an estimate.
Yeah, total 18 to 22-ish, approximately.
Would you consider them a small operator?
Myself, I mean, there's a spectrum to that, right? I would say comparably at the time in New Mexico, they probably would have been not medium, but I guess, yeah, smaller.
And so then jumping ahead from mobile data where you were working in the Bakken in North Dakota, when did you return to operations in New Mexico?
2017.
And that was with Marathon, is that correct?
Yes. Marathon had purchased 2 or 3 smaller oil companies here to get back into the Permian.
And so the wells during that period, how would you describe them?
During 2017 and all the way to 21?
Yes, sir.
A mixed bag. You had marginals. You had ones that hadn't produced in multiple years. You had brand new ones that we were bringing online. It was a very, very mixed bag during that time.
Okay. So in terms of the Marathon's portfolio at that time, did you consider it to be high risk or risky?
Yeah, for the wells that we obtained, I would agree with that. Yeah.
Have you done any analysis? I mean, in other words, in coming up with your opinions today, have you looked back and done any type of well by well analysis of the 150 to 250 wells you were overseeing during that time period?
No, I have not.
But your opinion that your employer at that time had a risky profile was based on the wells you were working on?
Correct. Off personal observation.
And is that limited to just the what you would consider marginal wells, or are you referring to the entire, portfolio or inventory?
Oh, marginal wells are definitely higher risk.
And so I want to dig down a little bit because you referenced decision making. In your final position as the production supervisor from 2018 to 2021, what kind of decision making responsibilities or authority did you have?
Well, I never really did have the final say on the actual budget. Bigger items. I believe there was a threshold of money that I could spend on my own, but I did provide a kind of rough equation that is very common in the industry about well payback periods. If I decided that I felt a well needed, something to be able to produce or produce safely, etc., then I would apply for what they call an AFE. And you have to excuse me, I do not remember what that acronym stands for, but that would then be approved by my upper management if it was feasible or not. And that most likely included, petroleum engineer or reservoir engineer looking at that as well. But as far as just day-to-day operations, decisions about who went where, I recommended scheduling, that type of thing.
So it sounds like there was a lot of management decisions in terms of where personnel were employed or what kind of maintenance, especially if it was a larger project that you needed to recommend. Is that right?
Yeah, I think that's right.
And do you remember that threshold number you referred to? Do you remember it kind of ballpark, or was it 20,000 or 50,000 or 100,000?
It varied. I know that it was never written right in a kind of an SOP or anything, but I think it was common knowledge that if it was, a marginal well, I think the limit was $5,000. But if it was a horizontal well, I could spend 100,000 if I wanted to.
And that was common knowledge, but I'm trying to understand how you knew it was 5,000 versus 100,000. Is that something that was just passed down to you?
Learned over time of experience. Maybe I overspent on a well that couldn't pay it back, and then just learned over time where naturally, holistically, where my boundaries were, where I needed to go talk to my upper management about spending.
And in your position as production supervisor with Marathon, were you ever required to review, or are you familiar with joint operating agreements?
No.
Okay. And I think AFE is authorization for expenditure. That's what I remember. And so no, without familiar with joint operating agreements, did you ever review any joint interest billing statements?
No, the furthest that I got into any joint was I basically knew what our working interest was, and I was to prioritize our highest working interest over the lower.
But you're definitely familiar with the scenario that there can be many interest owners in a well or in a lease.
Preferably, yeah.
But it sounds like so when you've made statements about the economics of a marginal well, and you've provided some figures in terms of either the lease wide or the larger picture, did that decision rest with your manager or your supervisor?
I'm unsure if it was my direct. It may have been a group effort with their supervision or their peers. Yeah, as far as like lease wide or anything like that, I'm not sure.
And then to narrow down a bit, there's lots of jobs within the oil and gas industry. It sounds like were you ever involved in any drilling of wells?
No.
Okay, and were you ever involved in any completions process?
Just the handover that gave them to me for the production.
And then were you ever supervising or involved in the plugging or decommissioning of a well?
No, not during industry.
And that your experience with plugging comes at overseeing the special projects group now, is that right?
At a 1,000-foot level, but
Okay.
we have technical people under me that handle that.
So in your testimony, page 1, line 14 through 16, and I'm going to share my.
Thank you. That was my
Great.
request. If we're going to ask Mr. Wrinkle, I would just ask the courtesy of sharing screen. Thank you, Ms. Tripp.
Mr. Wrinkle, can you see here? I'll scroll back up to the top. So the top line says direct testimony of Justin Wrinkle. Are you looking at the same thing I am?
Yes.
Okay. So in line 14 through 16, where you refer to, you make a statement, those oversight duties included budgeting, cost analysis, production data analysis, facility builds, safety, environmental efforts and reactions, workforce management, and project management. Those duties are specific to your time with Marathon between 2017 and 2021.
Yes.
And so what kind of budgeting authority did you have?
We basically had to, every year, right, you had to forecast. And, I was over, my field, right, and had to forecast out what we were going to spend on numerous different line items. Yeah, I mean, that's basically what we did. Day-to-day budgeting, I would use the equation I used a little bit later about, what kind of costs we could use well by well basis, though, strictly well by well.
And so your analysis was limited to a well by well basis to the extent that a review of projected revenue, projected expenses was made either on a larger lease wide or even a company wide portfolio. That was not something that you participated in.
No, the only part that I was privy to on a company wide would be a line item that got charged to every well that was basically administrative expensive payroll, that type of thing. So that factored into your LOE for each well. At my level, we weren't broken out by lease. It was well by well.
Thank you. And I'm going to hopefully sharing my screen again. This is on to page 2. Excuse me. And I just want to make sure that we're all talking about the same types of wells. So when you refer, this is line 2 and 3, when I refer to marginal wells in my testimony, I define those wells that have low production, are aging, and hold little value as an asset other than the lease. Is that correct? That's the definition of marginal well you used in your testimony?
As I know it, yes.
And so by low production, what level of production are you using as low?
Like I said, it's been so long ago. It was in line with what the proposal is. I can't give you any rock solid numbers, but low comparatively to the rest of actual economic wells.
And so earlier you testified that when you were working for Marathon, that they had a wide variety of wells. And so the definition of low production is based on your memory or estimate, but it's not based on any actual analysis of the wells at that time.
No, I wouldn't have that information anymore.
And then in terms of wells that are aging, what is there a certain age that you would assess as being older or too old, or what criteria are you using to define that term?
I guess anything spudded before 2000 is kind of the rough year that I put in my head.
And so since at the time you were at Marathon as the production supervisor, that was up to 2021, you're thinking about wells that are 20 years older or 20 years or older?
Yeah,
Roughly?
and that would fit the aging definition, but of course there are younger wells that meet the low production.
So would you include, so I think, and this may bring back some nightmares from yesterday, but are you referring to marginal wells that are low production, aging, and hold little value as an asset? Or do marginal wells capture all wells that are low production or aging or hold little value?
You're going to have to repeat that.
Sure.
Confusing.
Are there 3 categories that could exist distinctly within marginal wells, being low production, aging, little value? Or do all 3 of those have to be found in the definition of a marginal well for your testimony here?
If it is a marginal well, it inherently, would have little to no value. So if that's overarching, right, then the other 2 are kind of moot, right?
And so what do you use? What's your barometer or yardstick for little value?
A well that cannot pay for its upkeep and operational expenses.
So it is, a marginal well is one that produces less revenue than covers operating expenses. Is that correct? Or I'm sorry, I don't want to restate. Can you answer the question again?
Objection asked and answered if she's asking him to answer her question again.
Yeah.
That's fair. Mr. Wrinkle, a marginal well holds little, is this a true statement? A marginal well holds little value if its revenue does not cover its operating expenses?
Yes, that's my opinion and with my experience, yeah.
But revenue generated from a well can fluctuate over time with market prices. Is that correct?
Mm-hmm. Yes.
And so there could be a wide range of whether revenue exceeds operating expenses or not within the same well.
Yeah.
Is that right? Okay. Mm-hmm. And that variation could occur within the same 12 months. Is that also correct?
It would have to be a pretty wide variation for very low production. I mean, the higher production and the more swing in your spot prices, right? Then you're going to have a higher a higher swing, lower production, lower swing.
Are there other factors that could affect whether a well produces or how much revenue it generates? Other than just market prices?
Are there other factors? Can you please?
Sure. Are there other factors that affect the revenue a well generates other than just the market prices, the West Texas Intermediate?
There may be. I don't know, unless, if joint venture things, I'm not sure about that. But all I am aware of is the production of a commodity that the asset makes is what its revenue is based off of.
Well, in the wells that you've operated, in your experience over 20 years, were any of I think some of those were gas wells, correct?
Yeah, a good majority in the beginning of my career, yes.
Are you familiar with takeaway issues or capacity for gas wells?
Oh, yeah, most definitely.
So there are other constraints that might be outside of an operator's control that would affect both production and revenue.
In specific circumstances, yes. Depending on their marketing agreement with, force majeures, that kind of stuff.
There was another area of your testimony I wanted to follow up with you about producing by exception. Do you recall that?
Yeah.
Can you explain that a bit more?
Yeah. So I can give you an example. If let's just say that you have a low producing well, and it's an oil well, and it's a pumping unit, and your rod's part, and it's decided that you're not going to invest the money to fix it. So you decide as a business decision to be able to keep producing the well and show some production. You let the casing build up once a week and you sell the gas off the casing. So there's really no need, if everything is shut in and secure, there's no need to have somebody out there every day, as if it was a pumping, producing oil well. You would send somebody there once a week, open the valve, sell a couple MCF, close it, and go back the next week.
But production by exception doesn't violate any of the rules.
No.
And would adoption of the proposed rules eliminate or affect the ability to produce by exception?
Objection to the extent that calls for a legal conclusion.
Yeah, Mr. Wrinkle, please don't offer legal conclusions, but if you have an answer otherwise, go ahead.
I don't.
Okay. So speaking of the proposed rules in the petition, have you reviewed those?
Very little.
Are there any specific provisions or changes that you recall reviewing?
I guess holistically, right? Just the main point of it is, if your well falls into this category, then you must secure a higher bonding amount.
So you've reviewed the portion addressing changes in financial assurance.
Objection. I don't think this is outside the scope of his direct. We are not presenting Mr. Wrinkle as an expert on the contents of the rules.
Yeah, and he's already, I think, shut the door on that. He effectively said he hadn't reviewed it closely.
Okay, we can move on. So moving to your demonstrative, which captures some of the testimony in Exhibit 7, which is Exhibit 9, there's an overview of lease operating expenses, correct?
Can you share it?
Yes, absolutely. And it's probably pretty small. Can you see this?
I can, and yes, that's
Okay.
correct.
Okay, so this is Exhibit 9, and we're on page 3. The first page is the introduction, and page 2 is sort of your experience. Let's see. I can get there. So page 3, which is where we start talking about lease operating expenses, and it continues from page 3 through page 4. And then there's some additional expenses categories under safety, environmental, and retrofitting. You recall testifying about this?
Yes.
Okay. And so I think I heard you refer to OpEx during your testimony. What is that?
Operational expense.
And excuse me, there's also some portions of your direct testimony that refer to capital expenditures or CapEx. So how are those two different?
We used them, and again, I didn't make these decisions. It was up to my upper management about what bucket they were going to place the costs associated with whatever well we were working on in, one being a CapEx bucket and one being OpEx or LOE.
And so in your analysis of whether a well is marginal, you're only using the lease operating expenses or the OpEx. Is that correct?
No, I just use all.
I'm sorry. So you used all of the variables that you testified in generating a range of OpEx?
No, I'm trying to, maybe I misunderstood your question, but to determine if it was profitable or can you restate it? Because I think I'm confused.
Absolutely. So let me get to that portion of your testimony, your direct testimony, just a second. Okay. A standard example, this is on page 2, line 11 to 12. And I'm not going to put up because I want to start moving a little bit quickly.
Could you please, if you're going to cross-examine him about direct testimony, would you please share or tell me where so I can share with him?
Absolutely. So I'm going to ask the question as I share. So Mr. Wrinkle, you use a standard example of a calculation for a well's profitability, and that's at page 2, line 11 through 12 of your testimony. Gross revenue minus royalties minus lease operating expenses equals net revenue. Is that correct?
Yeah, that's a standard, and it's loose throughout the industry. And I believe it was invented, right, for be able to have field personnel make, quick decisions on the other equation in here about, like, can it pay itself back within a certain amount of time? And it's just basically so people can work a little bit more autonomously without having to go to management.
Okay, and so that term, lease operating expense, does that include expenditures that you identify as OpEx and expenditures you identify as CapEx?
Oh, okay, I see where you're going.
Is
Okay.
my question.
Yeah, no. So CapEx will not be under your LOE in that equation. My point in the direct is that it just depends really on management in the company of what they're putting in CapEx and what they're putting in LOE. But it's my opinion that a cost is a cost is a cost.
Okay, but that's not necessarily how the wells were operated at the time that you were employed with Marathon.
Can you be more specific? What do you mean that way they were operated?
So to the extent an expense was assigned to CapEx, the CapEx bucket, and not a lease operating expense. I'm trying to understand in your analysis whether capital expenditures are included in your lease operating expense.
No, they are not. It would be lease, whatever was categorized as lease operating expense, whether if that last week was CapEx and then this week they decided to put it under LOE, then that's in that equation, we would only use LOE.
And so in coming up with a range of lease operating expense of $500 to $1,500 per barrel of oil equivalent produced, what did you use to create that range?
It was a few examples over my time here in New Mexico in the latter part of my career where, something happened, right, to a well that did not produce very much oil or gas, to where you had no choice but to replace tanks, that was a large expense. I believe one of them was a remediation cost after a failure of a vessel that was aging. And, you know, once you put that and the company decided to put it on LOE, then that's what drives that equation to those drastic numbers. I wouldn't say that it's common. I would say, you know, 5% of the time you would see that, and we would have to manually manipulate our reports to take that average out for all the rest of the horizontal wells to have an actual, you know, good looking report.
So that range of $500 to $1,500 is based on a handful of specific examples from your experience.
Yes.
Okay. All right, thank you. And I'm going to quickly run through some of the expenses that you've identified. Field operators, is that based on the most recent experience, 2017 to 2021?
Yes.
Okay, and those numbers are numbers that you pulled from looking at any of old expenses or old well economics?
Are you talking about the pumpers, the field operators that I believe I said it was $1,500 a day average?
Yes, over 50
Okay.
leases.
Yeah, and the second part of that was basically just an example of how one may break it up between, you know, a certain operator's route. But 1,500 burned in my mind since 2021 because that factors in, you know, your truck lease if you're owning it, all the HR type of expensive workman's comp, insurance, all that stuff was given to me. And we ran with that for at least 2 years as being an approximate expense.
And then I believe you also testified earlier that these expenses are very well dependent and can also vary widely depending on the well's needs. Is that right?
That is correct, yes.
So it's an individual analysis on a well. It's not necessarily tied specifically to a production threshold.
What would be tied to a production threshold?
In terms of these expenses, whether a well would need it or not is individual and specific to the well.
Would need what? I'm sorry, I'm just getting off
Would
track there.
need to incur these range of field operators, energy, compression, hot oiling, waste removal, road access, chemical treatment. Like those are specific to the well.
Correct, of what they needed and if you decided to invest in that or not.
And there's another comment that was made regarding the value of a well holding a lease. Do you recall that?
Yes.
And you experienced that in your position with Marathon. Is that right?
Yes.
Did you see that side of the analysis when you were working with smaller operators like McKay?
No, I wasn't high enough up to know those things.
And at the time that you were working for Marathon, was its specific business model focused on stripper wells or marginal wells?
I think it was more new drills.
And so your employer at that time was maintaining marginal wells to explore an area for horizontal development. Is that right?
Not entirely. I mean, we did have legacy production, right? That we treated just like any other production that you would have new. You would use those equations that I showed, and you know, acceptable risk analysis, those type of things. But yeah, some of them were basically there for the lease development.
And so, are you aware of any of these marginal wells or lower producing wells that were plugged after new development came online?
Off the top of my head, I can't tell you the names of the wells, but there are at least 4 or 5 that were.
Okay. So that's somewhat common in terms of bringing new wells online and then plugging the well that was holding the lease if it's at the end of life.
If it's deemed to be at end of life and you can't find somebody that wants to take it from you.
Okay. Have you reviewed any other testimony offered by witnesses in this rulemaking proceeding?
I've been listening, as far as to review in detail. No, I have not.
Okay. And so I think you've already covered this, but in terms of the decision maker and whether it's an operating expense or a capital expenditure, that occurred really outside of your authority.
Yes, it did.
Okay. And so an operator, to the extent that the expenses you've listed, if an operator perceived that as a capital expenditure, that would affect your equation.
Not if they perceived it as a capital. It would not affect the LOE, the equation we were talking about earlier, minus revenue, minus royalties, or not minus revenue, excuse me, minus cost, minus royalties equals revenue. CapEx wouldn't affect that.
Well, if it's a capital expenditure, you're still considering it a lease operating expense?
No, I think I covered that. No.
Okay, I'm
yeah.
sorry, maybe I'm misunderstanding.
Hmm.
Ms. Tripp, you have 5 minutes.
Thank you, Madam Hearing Officer. And so, Mr. Wrinkle, in your position with of 20 years, you managing costs, reviewing those things, have you reviewed invoices from contractors from time to time?
Yes.
Okay. And when you review those, are you looking for reasonable charges or reasonable explanation of charges?
Yes.
And are you familiar with receiving an invoice and then there's supplemental materials like a work ticket for specific employees? Have you seen that arrangement?
Yeah, in when I was in industry, I don't look at any invoices here, but yeah, in industry they often did have a work ticket associated with the actual invoice.
And if you had seen that 10 employees were billed for the day, but you only received 4 employee work tickets, would that have prompted any action when you were reviewing for industry?
It may have, depending on how busy I was.
That's fair. It's similar question. If you had a contractor going out to work on 2 wells that were located very close to each other, and you saw that mileage was billed for both wells, would that prompt any question for you?
It may, depending on how busy I was at the time.
I think you've already stated that you don't review any of the costs with plugging out of the special project teams. You're not involved in that invoicing system.
No, I do not.
Okay. Would it surprise you if other operators, small operators who might specifically or who might specialize in lower producing wells, marginal wells or stripper wells, that their lease operating expenses are much lower than what you've testified to?
Well, I testified to a range of possibilities. So if they're just using a few of those, then it wouldn't surprise me. And these are normal. If you're just using the bare minimum in lease operating expense, then yeah, it's going to be low. But if something happens, that's what I'm trying to say in my testimony, you're going to incur that larger cost, and the low production is just not going to cover it.
After excuse me, drafting your testimony, and we have the demonstrative, did you actually add up all of those charges in terms of what the range would be from low to high?
No, because they were ad hoc. I didn't see a reason to. This wasn't every marginal well has to have every highest expense on this list. It was more of a, you may incur these charges if the well needs it. So I didn't see a reason to do that.
And so the lease operating expenses are highly dependent on a well's characteristics and what kind of well it is, its age, what kind of gas it's producing or oil. Is that fair?
Yes.
Madam Hearing Officer, I don't have any further questions.
Thank you, Ms. Tripp. Mr. Suazo?
Sure. Good afternoon, Mr. Wrinkle. My name is Miguel Suazo. I'm representing Namoga. How are you this afternoon?
Doing good.
Excellent. I have a few follow-up questions. I'm going to try not to cover some of the subjects that Ms. Tripp covered, but I want to make sure I understand the scope of your testimony and that it's clear for the record. Your testimony is about operating costs and practices, not statutory authority or rule interpretation. Is that accurate?
Yes.
Okay. And as part of your testimony, you haven't done a statewide statistical study of marginal well economics, correct?
No, I have not.
You're primarily or solely describing your experience and providing a set of example cost ranges for these wells, correct?
Yeah, that would explain it. Yep.
Okay. Now, you define marginal wells by low production in which you call lease operating expenses or LOE. Is that correct?
I describe marginal wells as, can you state that again? I'm sorry.
You define marginal wells by low production and lease operating expenses, correct?
No, no, I don't think lease operating expenses inside the definition of marginal well, unless I think low production, aging. I think when she pulled it up earlier, I think that's what it said in my direct.
Okay. Then maybe explain to me, if you can, how lease operating expenses tie to what you consider to be a marginal well.
Well, I mean, every well, non-marginal, marginal, has lease operating expenses. So my testimony was geared at mainly what I have seen in the past while dealing with low producing, aging, what I consider marginal wells, of what LOE they could incur.
Okay. So there's no universal production rate cutoff for what you would consider marginal?
I did the best that I could to recall the different fields and what their spectrum of production was. It varied from something that we were producing 2 MCF a month to, 47 barrels a year, right? But those, in my mind, are considered very low producing marginal wells.
Okay. And I'd like to better understand LOE and how you think about it. LOE, does that vary by basin?
It definitely can, because different basin characteristics of wells are going to need different things, right, done to them monthly. Yeah.
And so things like the infrastructure in the vicinity, the distance from facilities, how operators choose to operate a well, that all factors into your assessment of what makes up LOE. Is that right?
Are you talking about in the planning stages, like how if they plan it before they buy it or before they drill it, that would affect the LOE in the future? Or are you talking about just what you have in front of you now?
Well, I'm trying to understand how you think about it. So if LOE factors into the planning stage, I'd like to know that. But if it factors into other time periods in which the well is operated, that'd be helpful to understand from you.
Okay, no, I was just trying to get a better idea of what you're asking, which is, it is what it is. I hate to say that, right? But like if you take a well and say you purchase it from somebody, it is, close to municipality. So you're going to think about, a certain cost per month on that if you want to put remote monitoring on it. Location, treatments, i.e. chemical, your pipeline is too high, then you're going to decide, maybe I need to compress this. Do I want to buy a compressor? Do I need to rent a compressor so I can compress the gas and shoot it down the pipeline? Maybe you've got an oil well that your low pressure vessels are venting to your tanks, and I'm going to be a prudent operator and not do that and report it on my 115. I'm going to invest into a VRU. Those are decisions that can happen every day, and it is basically ad hoc, right? And it is very specific to the well characteristics.
Okay, so I like that explanation. I think that gives everybody a sense for what I would, I guess, characterize as a wide variation of LOE that is well field specific, correct?
Correct. Mhm.
Okay. And you said that you have looked at the rules, but not extensively. Have you looked at them sufficiently to assess whether if the rules that are being proposed in this proceeding are adopted, whether that will increase operating costs and LOE?
Because I don't have prior experience on the bonding and premiums for oil and gas, I don't know what that increase would be. So I couldn't give a number on that, or have an opinion about that, because I just don't know what that cost would be.
But you do agree that the costs would increase, correct?
I don't know. I don't know anything about the insurance or bonding or deals that could be made in that arena.
Okay. So in your testimony, you use a personal, I guess what you would call a rule of thumb. And that is whether the lease can break even after 6 months of gross production. Is that right?
Yes, and it is, I guess you could say it is personal, but it's very widely used in the industry for field foremen and those level of decision makers. Sometimes it is a year, sometimes it's 3 months, sometimes it's 6 months. It just depends.
So even though it's widely used, it's not an industry standard though, necessarily, correct?
Yeah, I mean, it's not published in API or anything, right?
Okay. And that is your personal rule of thumb based upon your prior work experience, correct?
Correct.
And that is not something that the commission or the division has adopted, right?
Well, the commission or the division don't operate oil wells. I mean, we plug them, but I don't know why we would need to adopt. You mean adopt it like when they're talking about financial analysis
Like
or economical analysis?
the division doesn't use a 6-month time frame to make that sort of assessment, just in general course of dealings, not with respect to, operating wells, P&A.
Yeah, we don't run economic analysis on wells in our day-to-day work. I don't believe, at least I don't.
Okay. Now, Ms. Tripp asked you a little bit about production by exception and deferral. And you testified in your direct testimony, the operators often produce by what you call exception, correct?
Correct.
And as I understand your explanation, that means turning on a well for, let's say, 1 to 4 days per month. And the reason why they do that is to avoid costs, but still hold a lease. Is that accurate?
Yeah. Overall, it could be for a few different reasons. For most of the time, I'm not saying all the time, but most of the time, if you are unwilling to invest, or you know that the well is at the end of the life, but it holds some monetary value to you other than its production, then you have to produce it and able to hold the lease. Now, I'm not a leasing expert or anything like that, but I do know that much, that you have to show some type of production. The example that I gave Ms. Tripp earlier about the rods, right, that had separated, and you're sending a person by there every week to open it up, so a little bit of gas out. That could be a temporary intermittent pumping or pump by exception until your rig opens up and you can go over there and get that. That's if, of course, you decide to invest the money in that well after you've used that kind of rule of thumb equation, in my experience.
Okay. And other than holding the lease or what you just described, are there any other reasons an operator would produce by exception that you can think of?
Well, yeah, I mean, force majeure. If you are cut out of your pipeline for repairs and it's a long period of time, then of course the need, right, to put boots on the ground there reduces until that infrastructure opens back up.
Okay. And you've seen remediation deferred to P&A where permitted, meaning that the timing of costs can be managed without proving whether a well is capable or incapable of beneficial use, correct?
Okay, deferred to P&A. I apologize. Can
So,
you read?
Yeah, let me be a little clearer. So I think when Ms. Tripp was asking you questions, she asked you about deferring remediation. Is that accurate?
I don't believe she asked me that about remediation.
Okay. Have you seen remediation deferred?
Peripherally, with my peers in our environmental department when I was in industry, they would, I would hope when they asked for it that we got it so I could turn my well back on.
Okay.
But I've seen it peripherally. Yeah.
Okay. Let's move on to some of the expenses that you listed in your direct. You list things like flare stacks, tanks, vessels. And those are, I guess, capital expenses or retrofit expenses that are tied to safety and compliance issues. Is that a fair assessment?
Sometimes.
Okay.
As normal CapEx normally is going to be when you're developing and you're building the facility and you're putting all those things in. After that, it's kind of, whatever you spend on it is going to be LOE. Now, if your management or, the owner of the company or whoever it may be feels that they want to put that on CapEx, then they tell their accountants to do just that, right? So I have seen tanks, flares, flowback, you name it, swapped in and out of operating costs and CapEx throughout my time as a decision maker.
Okay. And I guess just so I'm clear about how you explained the distinction between CapEx and OpEx to Ms. Tripp, it's your opinion that those two buckets of categories are dependent upon the judgment of the operator, correct?
That's what I think, because in my experience, seeing it being switched, that's my experience. I've just seen it be switched at random. So in my mind, that's what I have seen. And
Okay, so you're not,
opinion, it's just what I saw. Right.
so you don't know whether there are generally accepted accounting practices that determine whether one bucket is used for CapEx or OpEx, correct?
The only one that I do know about is usually the development, right? Of course, your drilling is going to be CapEx. I mean 99.9% of the time, I assume. Your facility builds, all the new equipment that goes along with when the well is new is most all the time going to be capital expenditure.
Okay. Now, in your direct testimony, you did not quantify how many wells in New Mexico require expensive retrofits in your list, correct?
Did I provide a list of wells, or you mean a list of expenses? I'm sorry.
No, I know you provided the list of expenses. I'm asking if you provided a list of wells in New Mexico that would require expensive retrofits as part of your direct testimony.
Oh, no, I didn't.
Okay. And you also did not compare your costs to operator reported average P&A costs, did you?
No.
But that would vary by.
Sorry, let me clarify that. I don't believe I put anything in my testimony about P&A costs.
Okay.
So I wouldn't have done that anyway.
And even if you had, those costs would still vary by basin or vintage of the wells, correct?
I'm not a plugging person. I don't know that.
But you supervised plugins, didn't you? I thought I heard you say that.
No, I oversee the group that supervises the pluggings here at OCD, which I have the technical people.
Okay. Thank you.
Yeah.
Understood. So you testified that marginal wells are often held to preserve leases, correct?
That is my experience, yes.
And then they're divested as a common business practice, but that's not inherently a step towards orphaning a well necessarily, correct?
No, you would just be divesting it, correct?
Okay. And in your experience, do operators plug a well when they can't sell it?
In my experience, yes. But of course, we've mentioned the name of the former company that I was with. They obviously, had the capital to do so.
So just so I understand, you're testifying that a well becomes marginal at 1,000 BOE per year, which comes out to approximately 2.7 BOE per day. Is that right?
I didn't put as I was answering earlier, I did my best to just remember the lower producing wells in my experience. I did not. There's no way I could go back and from the company and pull those numbers. So I didn't define a marginal well. I don't believe in my direct.
Are you aware that that's how applicants define it in their application?
Through listening to testimony, yes, and then the great and or question as well.
Okay. And so your range in your testimony is somewhere between 500 to 1,500. Is that correct?
500, 1,500 what?
LOE?
Oh, for LOE lift operating expense at the very end of my testimony about how it's per barrel that we were
Yes,
looking
sir.
at. Yeah.
Mhm.
I mean, yeah, in some cases, I think I told Ms. Tribb like 5%, or 5 or so that I've had in the past have done that because of unavoidable, not catastrophic, but costs that you had to spend on these wells that were low producing. And I think on a few of them, it would have taken another 75 years or so, or one of them was like 600 years to pay off that expense.
But using your range, the 500 to 1,500, if there's production at 2.7 barrels a day, that's still profitable, correct?
If it produces every day, at that rate, then sure. And it wouldn't be marginal, I don't believe. Would it be? Or on the cusp? As long as you didn't incur any costs, yeah, probably would be.
Okay. Mr. Wrinkle, I thank you for your testimony. No further questions from NMOGA, Madam Hearing Officer.
Thank you, Mr. Spazo. Mr. Sayer? All right. Mr. Rankin?
That's me. May I prevail upon the commission and the hearing officer to take a short break?
All right, let's take 10 minutes. Come back at
Thank you.
2:15. Let's come back from the break, please. We are back after a short break. Mr. Rankin, do you have questions of Mr. Wrinkle?
I do have a few, Madam Hearing Officer. I don't have many LOE questions. This was thoroughly addressed, but I do have some other questions. I have a few maybe LOE questions, but a few others. Are we back on the record? Oh, yeah, okay. Thank you. Thank you, Madam Hearing Officer. Mr. Wrinkle, my name is Adam Rankin. I represent OCC in this case. Thank you very much for your time today, your engagement in the rulemaking and your testimony. And to the extent that you were involved with the division discussions with OCC in advance of this rulemaking, discussing proposals and trying to reach agreement, I'm grateful for that as well. So thank you for your engagement. I'm going to turn to your testimony here. And every time I refer to your testimony, I will pull it up so that you can see it. And if for sure, 100%. Okay. All right. Line 18 in your direct testimony on page 1, you state that New Mexico has been one of the leading states in orphan well mitigation. And I just want to say, I just want to explore that a little bit because so far we've been hearing a lot of the problems, but I want to understand this is a positive, and I want to understand a little bit more about, in your view, how it is that New Mexico has been one of the leading states addressing orphan well issues.
Multiple, the 2 or 3 conferences that I attend, as my role here, I've heard this many times through I can't quote the reports, right? Possibly some acronym groups that have said that New Mexico has plugged X amount of wells and are leading the nation, et cetera. So this statement is just from my personal involvement in different conferences and hearing it.
We've just been hearing a lot about how there's I'm going to paraphrase, but an impending wave of issues, negative issues, and potential orphan wells coming. But it sounds to me, based on this statement and what you're telling me, that New Mexico is actually being recognized as doing a fairly good job of managing its orphan well situation. Is that what you're telling me, based on national conferences that are addressing this issue?
Well, I wouldn't say, maybe it's worded wrong here, but managing what orphan wells that we have been placed in front of us, if that makes more sense, the operational side of it, not the getting in front of, if that helps.
And you'll see I've got the next or the last sentence of the same paragraph partially highlighted. I'm going to focus on the I'm going to focus on the first half of the sentence before I move to the second half. I'll highlight it too. Okay. This last sentence here says the proposed changes will allow New Mexico to enforce responsible asset management. And I'll leave it right there. I'm going to just ask a couple questions just to kind of tie the loop up on this, but I heard you say that you haven't really reviewed the proposed rule carefully or in depth. So did you do any kind of analysis or review of how the changes in the new rule would impact or affect OCD's implementation of the orphan well program that you oversee?
Well, I oversee the operational side of the orphan well program, just for clarity. So what was the first part of your question? That was a 2-parter, wasn't it?
No, I guess the first part is, well, I don't know if it's a 2-part, but the first part is, because you didn't really closely review the proposed rule, did you do any kind of analysis to determine what the changes in the rule would have, what kind of impact those changes would have on your management of the orphan well program?
No in-depth analysis.
Okay. So when you say that the proposed changes will allow New Mexico to enforce responsible asset management, what do you mean by that? What would it do?
Yeah, well, it's just a holistic statement of if you require well bonding, right, that is more in line with what it costs. If, and hopefully we don't receive orphan wells, then the state, right, will be able to be more in line and not be upside down on the cost if they do, recover bonds.
So the statement there, your opinion is at that high level. It's not specific to any specific provision or rule amendment. It's just a general statement about if that's the effect of the rule, then it will allow the state to better manage orphan wells.
Yeah, I would agree with that.
Okay, so just a high level statement, but not based on any specific rule or amendment change, right?
No, I mean, well, the change, of course, of the bonds being single and higher, right, but not any specific line item detail.
Okay. And just so I'm clear, as the Engineering Bureau Chief, you oversee Mr. DD?
I oversee his group, and Mr. Didi is in Mr. Garcia's group under the engineering special projects.
Okay. And so the Engineering Bureau, Mr. Didi's plugging program is generally underneath your oversight and management, correct?
Yeah, I guess you could say the buck stops with me there.
In the lead up to this proposed rulemaking, did the division did anyone at the division seek your input on the effect of these proposed rules and whether you would recommend any changes or modifications to them?
I'm trying to remember. We're pretty busy over here. I believe in passing, maybe at the end of a meeting, somebody may have pulled me aside and ran me through very high level and got my pulse on it, but I can't guarantee that. But not in a formal way, no.
So you weren't asked as the Engineering Bureau Chief to do any kind of review or analysis of what the rule would mean for implementation or management of the orphan well program?
Because and the reason I think I wasn't involved at that granular level is that as of right now, engineering is purely an operational part of it.
When you say
and not
operate,
policy. So we plug the wells, right? And,
Right.
Price agreements, policy, what it would do to operators. We just do the operational side of things. So that's probably why, I wasn't granularly consulted, trying to look for the word there.
but based on the rule, I mean, it's going to have an impact on the division, right? You're going to have, in terms of the operational side, right? I mean, there's the policy aspect of it, whether to support the rule, what the broad policy implications are of the rule. But certainly the rule is going to have an operational effect on the division, and in particular, your orphan well program that you oversee, right?
Objection. I believe Mr. Wrinkle has already testified that he has not studied the rules in depth. And so that question, I think in that sense, he has already answered. And that's the basis of OCD's objection to that question.
I think he was pretty clear about that.
That's
Mr.
fine. I'm
Rankin.
happy to move on. I just, I try to close the door on things maybe once or twice, too many times. That's fine. Okay, so all right. So I asked you if whether you did any kind of review or analysis on the impact of the rule to your program and implementation of your orphan well program. Do you know, and you told me you didn't, do you know if anyone else at the division did that kind of review or analysis of the operational impact on your orphan well program?
That I do not know the answer to.
Okay. on the second half of this sentence, on page 1 of your testimony, where you say that the proposed changes will allow New Mexico to enforce responsible asset management and more effectively recover financial assurance when the state plugs and abandons well bores in oil and gas facilities. I'm going to ask you about this, and you can tell me what you know. But you're telling me here that the proposed rule will allow for more effective recovery of financial assurance. So my question to you is, first of all, tell me what you know about recovering financial assurance currently at the division.
So, sure. I don't know anything about that, but the statement, and it may read a little odd, but the meaning I was trying to get across is more effectively cover the cost, and it's not worded really great here now that I look at it, but more effectively get actual cost back for what we've spent plugging orphan wells.
So you're telling me that you meant to say more just that the rule would allow the actual costs of plugging to be covered, whereas currently, in your opinion, the actual costs are not effectively covered by the financial assurance.
Correct.
And not that it would make the it would be not that it would make it easier for the division to actually go out and recover or redeem the financial assurance from the surety companies.
Correct.
Okay.
Mm-hmm.
And you don't, as part of the engineering bureau, you don't oversee the financial assurance aspects of the division, right?
No.
So those questions all will be directed to Mr. Powell, correct?
Sure.
He's the last one.
Yeah.
Okay. All right. And I think also your testimony about the use of the term marginal well and what it meant to you in your testimony, I think was fairly well covered by Ms. Tripp, so I don't want to rehash that same ground. But I do want to kind of touch, tangentially around some of those discussions that you had with other counsel around your determination about whether a well maintains value independently of the lease.
Mm-hmm.
And I know in your experience working with Marathon that, in your opinion, oftentimes those wells were held primarily or for purposes of holding the lease, right?
That was my understanding.
Yeah. But isn't it true that many times, the well, a well has independent value because it provides access to, it may, depending on the quality of the reservoir, if there are remaining recoverable reserves, especially in primary production, a well that has access to those reserves continues to maintain independent value. Wouldn't you agree?
It depends, right? It's not producing for a reason. There could be downhole issues, that kind of stuff. That's something that you probably wouldn't want to re-enter. But you may.
Let me stop you there because I may not have framed my question clearly enough. I don't mean a well that's not active. I mean a well that's actually producing and meets the proposed rules definition of marginal. Okay.
Okay.
So a well under the division's, the applicant's proposed rule that meets the definition of marginal, meaning it produces less than 1,000 barrels oil equivalent and fewer than 180 days a year. But it accesses a reservoir that has remaining recoverable reserves in primary production. Doesn't that well maintain potentially substantial value, not just for primary production, but for future potential EOR or secondary recovery?
It may. It's hard to answer that without looking at a specific well, and having a qualified person run economics on it. It really, and I hate to keep going back to this, but it really depends on a well by well basis. Now, for a well that you're saying that would, in the petition, is under this category, I would say in my experience that you probably, would not want it to have any type of failure that's going to cost you any substantial amount of money, because then one or two of those things have basically made any revenue not possible for however long it would take to pay it back, in my opinion, other than, this lease accounting type thing.
So, I mean, I think throughout the course of this hearing, I think a lot of the parties probably would agree that it does depend on a well by well basis. And would you also agree with me, Mr. Wrinkle, that the division has the expertise to ascertain whether, given the information needed to make such a decision, it could make that decision about whether a well has future value and going forward?
Objection. That question involved a long statement from Mr. Rankin that I don't necessarily want to be incorporated as a question to Mr. Wrinkle unless he did mean those as distinct questions, in which case I would object to the question being multifarious.
Would you rephrase, Mr. Rankin?
Sure. Let me try to break it down if I can. Let me try to back it out. I mean, I think what I'm getting at, Mr. Wrinkle, is that wells may have, on a case-by-case basis, it's worth, sorry, hearing the whispering on the side of my ear, which is distracting. Wells have potential value, and so in order to determine whether they have value, it requires a case-by-case assessment. Agree?
Yes.
Okay. And my question to you is do you agree with me that the division has the expertise to evaluate whether, on a case-by-case basis, a well has value and beneficial use going forward?
To properly answer that, would the division be the one running the economics, or would it be an operator presenting its findings to the division for the division to make that decision?
I would say it's the latter, that the division could request information from the operator, and the operator would provide whatever information the division asked for that's relevant to make the determination.
I believe so. Yes. At current, with current staffing and their backgrounds, yes.
Isn't it also true that if a reservoir is near the end of primary production and a marginal or low producing well is plugged, that it may not be economic to drill a new well to access those same reserves?
I've never been involved in reservoir engineering or drilling or that aspect of management in the industry, so I just really don't have any experience to answer that.
Very well. So yeah, you wouldn't be able to tell me one way or the other then on that question, huh?
Correct. Yeah.
You mentioned that as part of your role in the Bureau, that the division is seeking primacy authority for the Class 6 CO2 injection, correct?
Yes.
And if you would just give us a short overview, what exactly Class 6 CO2 injection is all about?
Well, it's basically carbon sequestration. So you take carbon, right, CO2, and you inject it in ground for storage.
And in order to do that, you're going to need facilities and well bores to make that injection, correct?
Yes, I would assume.
So that's a possible future beneficial use of wells in the state if they're in condition and meet the requirements of Class 6 injection, that they could be converted to sequestration wells, carbon sequestration wells, correct?
Nothing is impossible, but I think for that particular scenario, it's going to be extremely rare with EPA's existing guidelines for materials and that type of thing.
Yeah, they have it's a high standard, right? Because of the corrosiveness of CO2 and water, right?
Correct. Yes.
But nevertheless, that's a possible future beneficial use of some of the state's well bores, correct?
Nothing is impossible, but extremely rare.
In addition, well bores in the state could also be valuable for on-lease produced water disposal, correct?
Pretty much the same answer that I gave about CO2. It's going to be rare because of the parameters that need to be met for injection across the board.
It's in your experience, it's rare for producing wells to be converted to disposal in New Mexico?
It's rare for people to make that investment rather than just going new. It depends on what type of injection you're talking about as well. Are you talking about EOR or are you talking about SWDs?
I'm sorry, I'm talking about produced water disposal, so just disposal. So I was specifically talking about lease, on-lease produced water disposal, as opposed to commercial.
Yeah, I mean, like I say, anything is possible, but it would have to, take a lot of rework or have been designed very, very well in the past. So it may or may not have that value.
Okay. In your experience, is produced water capacity at a premium in New Mexico right now?
I would say yes. Mm-hmm.
So, I mean, isn't it possible, even likely, that if operators are able to convert produced existing production wells to disposal to manage their on-lease water production, that may have some value to operators across the state?
Yeah, if they were able to meet those guidelines and then criteria, it would help that operator.
Did you review Oxy's witnesses' rebuttal testimony addressing your statement that marginal wells hold little value as an asset other than for the lease itself?
No, I didn't.
Okay. I'm going to see if I have any more questions for you, Mr. Wrinkle. I guess just kind of going back real quick to your testimony on lease operating expenses. These were all just based on, as far as I could tell, based on your anecdotes and your recollection of what the costs were, and not based on any actual cost data or case studies that you performed. Agree?
Yeah, I agree. I wouldn't have access to that anymore.
And in your testimony, you did not offer an opinion that marginal wells are more likely to be orphaned and fall to the responsibility of OCD to plug. Agree?
I don't believe so.
Okay. I have no further questions of the witness, Madam Hearing Officer. Thank you. Thank you very much, Mr. Wrinkle, for your time. Appreciate it.
Thank you very much. Mr. Rankin. Mr. Maxwell, do you have questions of Mr. Wrinkle?
No questions. Thank you.
Thank you. I don't know if Ms. Nanasi is on the platform. No. Mr. Moore?
No questions. Thank you.
All right. Mr. Tisdale or Ms. Fox?
No questions, Madam Hearing Officer. Thank you.
All right. Mr. Hall, do you have redirect?
Just a couple of questions. Mr. Wrinkle, I know it's been a long day. I'll make it quick. These lease operating expenses, I believe you testified they're variable and dependent, were kind of well specific. Were you able to predict when and where these expenses would arise?
To a somewhat degree, right? Depending on location, the visible inspection of equipment. Yeah, so, some of these, right? But like some H2S can show up out of nowhere, right? But visual inspection and that kind of stuff is pretty self-explanatory, and you're going to know at some point you're going to have to do X, Y, or Z to maintain it.
And regardless of some can be expected, some can't. Regardless, with regard to a low producing well, in other words, it's not highly profitable. Is that a correct characterization?
Yeah, I mean, it could be minuscule profitable, but yeah.
So what would the effect of these sorts of expenses, whether unexpected or expected, how would that affect the lease LOE calculations, lease operating expenses?
Sure. Yeah. So at the end of my testimony, I gave a couple, extreme examples of that, to where, this catastrophic thing happened. And it took LOE, $500 you're paying to get one barrel out of the ground, up to, the extreme of $1,500. Each time that you incur any of these that I listed, it's going to affect, your lift operating costs and diminish it each time. And yeah, in my experience, it's these lower producer, older ones that actually require this type of work more so than the newer ones.
Thank you. I'll pass the witness.
Thank you. Commissioner Ampoma, do you have questions of Mr. Wrinkle?
No, I do not. Thank you.
Commissioner Bloom?
Madam Hearing Officer, I have no questions. Mr. Wrinkle, thank you for your time today.
Thank you. And Chair Chang?
No questions from me. Thank you.
All right. Thank you. If there's no reason not to excuse Mr. Wrinkle, we'll excuse him. Thank you very much, Mr. Wrinkle. Mr. Tremaine?
Madam Hearing Officer, our last witness is Brandon Powell. He is here
the
in
room.
person.
Yeah.
We're happy to start with his direct unless we need a break before we start. I do anticipate that Mr. Powell will take the full 60 and 30 minutes, and we do have a number of questions for Sir rebuttal.
All right. Thank you. It's up to you. We did just take a break 30 minutes ago. We could take a break between direct and rebuttal if you want.
That's all right. Sorry, I stepped out for another matter. I missed the break.
Oh, okay.
Okay. Thank you.
Mr. Powell, would you spell your first and last name, please?
Brandon, Brandon, Powell, Powell.
And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Tremaine.
Thank you. Good afternoon, Mr. Powell. Will you please describe your current position with the OCD for the commission?
My current position is Deputy Director with the Oil Conservation Division, specifically over the engineering and environmental groups.
Thank you. Bear with me here. I'm going to ask you about a bunch of different exhibits. Mr. Powell, did you prepare direct testimony for this hearing, which is labeled as OCD exhibit number 13?
I did.
And is your curriculum vitae OCD exhibit number 14?
It is.
And did you prepare a visual aid for your direct testimony, which is OCD exhibit number 15?
I did.
Okay. Did you also, through council yesterday, produce a replacement Excel sheet for well production for fiscal year 24, which is a replacement of OCD exhibit number 16?
I did.
Are you in your testimony today going to refer or infer to the master reference spreadsheet exhibit number 17?
Yes.
And did you produce and refer in your direct testimony to the Legislative Finance Committee report on orphan and inactive wells, OCD exhibit number 18?
Yes.
Did you provide a second visual aid referencing your response to the LFC report in OCD exhibit number 19?
Yes.
Okay. Did you also provide 3 different forms of the inactive well list in their native format, labeled with different filters labeled OCD exhibits number 21, 22, and 23?
Yes.
Okay. And did you also prepare and provide for this hearing an exhibit labeled ACOI, or Agreed Compliance Order for Inactive Wells list, OCD exhibit number 24?
Yes.
And did you also provide a financial assurance report in OCD exhibit number 29?
Yes.
And did you prepare written rebuttal testimony labeled OCD exhibit number 30?
Yes.
And did you also prepare a visual aid for your rebuttal testimony, OCD exhibit number 31?
Yes.
Okay. I think we've gotten through the list here. Do you have any corrections to your direct testimony?
I don't believe so, but there's a lot there.
Okay. Similarly, your rebuttal or your visual aids, any corrections you need to highlight for the commission and participants?
No.
Okay. Do you adopt your direct and rebuttal testimony as your testimony today?
Yes.
Okay. And are you prepared to provide a summary of your direct testimony and a response to the LFC report as a summary of your direct testimony for the commission?
Yes.
Okay. No. Okay. Thank you. All right. Madam Hearing Officer, I'm going to screen share. All right. Mr. Powell, I have up OCD exhibit number 15, your direct slides. Please present your summary to the commission and let me know if you'd like to change the reference on screen.
As long as we can go to exhibit number 13 after we go through exhibit number 15, I'm fine with that.
Would you like me to refer to exhibit 13 first?
Yes, please. I won't stay there long. I know everybody's got lots of questions for me, so I'll try to be as quick as possible.
Please direct me where you'd like to go within exhibit 13.
I'd like to go to page 3 of exhibit 13. And what I'm going to attempt to go through my testimony is just a really high level overview of key points I think the commission should take a look at as they go through it. It's not inclusive of everything that I submitted. Obviously, as you went through the list, there's a lot submitted there, and I want to be as respectful of time as I can. So I'm going to run through as fast as I can, but calling key points out as we go through. So on page 3, actually, if you'll scroll up a little bit, because I want to start on line 1 through 4. As you've heard, and I think it's going to be continued through the case, the overemphasized conversation that OCD's costs are inflated for plugging and how they shouldn't be used, and industry can plug it cheaper than OCD can. I will just admit that industry probably does plug wells cheaper than OCD does. They look at wells at different points in the life than OCD does. Typically, the wells that OCD gets are by operators who are failing in their business. So what happens is they take the well's production to failure. And once that reaches failure, they leave that well sitting there until the next well gets to failure, and then they leave that well there. And they do that until OCD takes enforcement action or there's no wells left. So there's times where those wells sit for years before OCD takes action. And then once OCD takes action, then OCD puts those on that MOS list for plugging in the future. And at times, depending on budgets, which the budgets today are agreeably greater than they once were, but depending on budgets, OCD could take years to get to those wells to plug it. So by the time OCD gets to those wells, there are potentially years and years and years of neglect of those wells because they were taken to failure before OCD ever got to those wells. So an operator that's prudently taking care of their wells are going to plug it right at that failure point or even before that, when the well hasn't silted in, when the well hasn't corroded, when it hasn't met a lot of those other issues that OCD typically sees. Next, I'm looking on page 4. Specifically, I want to call out lines 12 through 15. And what I want to highlight here is private wells account for roughly 15% of the wells in the state. They account for roughly 40% of the inactive well numbers. Why this is important is on federal wells, BLM has oversight in their rules. On state land office has oversight in addition to OCD. On private wells, neither one of those organizations have oversight. It's just OCD. And it's concerning that operators are treating private wells potentially different than the other well types because 40% of the inactive wells in the state are on private land. Next, I'm going to point out lines 17 through 18. This was documented in the LFC report. 33.7% of inactive wells haven't produced in over 6 years. So what this highlights, again, is the inactive wells as they sit there for years before OCD gets to those wells, they continue to degrade. Next, I'm going to point out line 21 through 22. In this, I want to highlight over 60% of the wells that OCD moves on are actively leaking when we move on to them. That shows that they have failed integrity at the surface, not even showing what's downhole problems are, but failed integrity at the surface when we move on. That's all I had in Exhibit 13. I can move to Exhibit 15 now. So I want to start specifically on slide 7. Actually, I don't. Let's go to the definition of marginal well. I didn't have it highlighted. I'm not sure quite what slide it is. It's probably further on than where you're at right now because I believe they're in alphabetical order. Or maybe not. Right there. All right. So there's been a lot of discussion on marginal well. I'll admit, I wish we hadn't used that as the term that we used in the rule. Because marginally well is something that's been used by industry on whether it's productive or not. It's been used by LFC reports that I personally have submitted to the director, which is then used in LFC as different criterias of evaluation. I believe operators use it of whether it's economic or not. For LFC, it's roughly 20 BOE because stripper wells are 10 BOE. So it's double a stripper well. So those are the numbers we've given to legislature in the past as a marginal well. In this rule, it is not used for either of those. In this rule, it's used as a well that is near the end of its life that has a higher risk of potential failure. That's why we looked at having both the volume and the days tied to it, because we're looking at it as potential failure. I'll get into it in the rebuttal, but the attempt was with the days, if you produce 950 barrels, but you did it in 365 days, you're probably operating that well at its full capacity. If you produce 900 barrels in 25 days, you probably aren't operating that well in its full capacity, and there may be an issue with that well. What we're asking is to identify those wells that aren't operating correctly towards the end of their life that are at risk of being orphaned in the future, and bonding those before they get to that point. As it's written with days, all an operator has to do is produce for 181 days and they don't have to bond it. It's that simple. Moving on, I'm looking at slide 7. So in slide 7, I just want to highlight these. As I go through, I'm going to highlight the changes we recommended directly to the rule from the original petition. Just to reserve enforcement capability we already have. Right now, the rule says 12 consecutive months of non-production. Then the operator has 90 days to fix that. We don't want to lose that criteria in inactive wells of the 12 consecutive months of non-production. So we're just adding that back in there to preserve the authorities we already have. Now, line 13, slide 13, I apologize, is just a continuation. While you get there, it's a continuation of reserving that authority. Now, slide 17. So the change we recommended in slide 17 is in changing it from beginning January 1st, because everybody just got back from the holidays. Operators are allocating what they're going to invest in fields. Legislative session isn't but just around the corner. And to save everybody headache, we moved that to May 1st. And then because we don't want marginal wells that are being bonded to be a constant burden on both the operator and the OCD, we're asking that report be pulled once a year, be available on that May 1st to know what has to have that additional bonding. That way, that bonding is addressed one time as it goes forward. The other thing I want to address in there, and it's been discussed a little bit, is in number 3, where we talk about the 15% or more. I think that's been discussed at length, that if an operator has over 15% of their wells in marginal and inactive category, they have to bond all their wells. That's something that I will admit is probably conservative at the 15%. I think Welk gave some slides showing the different capacities that are there. We're going to go into some of the numbers and operators potentially in my SIR rebuttal, but that is something we expected to have some negotiation with industry, where they brought some real data to OCD or to the applicant to have those conversations, because it could be 15%, it could be 30%, or it could be marginal wells or marginal and inactive wells or just inactive wells. But that was something we expected to have some dialogue on based on numbers industry could pull and some back and forth on statistics that they could pull. And that never happened. We never got reach out from industry on what that number should be or what their recommendation was. Now slide 33. So there was some discussion earlier on whether we should use 90 days, 30 days. In regulatory sense, there's not a lot of difference between 90 days and 30 days, but we supported the 30 days simply because when 30 days was or 90 days was initially used, that was there when I started with the OCD. Most things were 90-day submittals because everything went through mail. Nothing was electronically filed. Some things had to have return receipt. Not only were things sent to us by mail, but it also took time to get them uploaded into the system. And this could have been back to the days at 90 days where we had hard copy files that once we approved it, the operators would have to come in and make their own copies. Now that we have electronic systems, everything is filed electronically. the operators can immediately upload this to the OCD and OCD can see it. And then once it's approved, the operator gets notification that day that it's approved. It's also not just 30 days. So when you look at this rule, it's 30 days on top of the 12 months it took them to get there. So by having it 90 days, operators don't have to do any planning until it's already been inactive for 12 months. So yeah, 90 days, we're looking at a presumption at 15 months. So we're saying operators, you don't have to plan anything for 12, and then you have to take action within 3. So by moving the 30 days, we provide inactive well lists on our website. I don't see us changing that. I also don't see us changing or not providing some marginal well list, those kind of things in the future, where operators can plan for that future. Our inactive well list, you can put in there any month that it's been inactive so you can start planning your actions, whether it's 6 months ahead of time, 9 months ahead of time, or 11 months ahead of time. Now 37, please. So what I really want to hit here, everybody is kind of stuck on the 90 barrels, 90 days. I have to go plug it. That is just the point at time where there's a presumption of no beneficial use. That doesn't mean an operator can't come in and show OCD where that well is still a beneficial use to the state. At 90 BOE, that may be a hard threshold for an operator to make, but that's still a threshold an operator can bring to the OCD and show that well is still productive, still's not an issue, and should not be plugged. So once you get a preliminary notice of non-beneficial, the operator submits information. It's not until there's a final determination on that well that action's taken. So all we're looking is, as was stated earlier, a well-by-well review at that time. I think that's all in Exhibit 15. I'd like to move to Exhibit 19 now. I'd like to start on slide 3, please. So slide 3 is kind of a summary of what was on prior slides. It's also a summary of other exhibits, but it's really to highlight there's a lot of risk out there right now for orphan wells that can potentially cost a lot of money. Over $1 billion potentially just in well plugging and or remediation will likely greatly exceed that. OCD has $118 million. And that sounds like, well, you're about 10%. The problem is OCD can't use that $118 million across the board. That $118 million is tied to individual operators. It's tied to Hillcorp, it's tied to Chevron, it's tied to Conoco, in addition to the smaller companies. So we can't use Conoco's bonding to plug a smaller company's well. So that $118 million isn't a bucket that we can use across the board. It is tied to specific operators, and not all operators are going to go orphaned. So even if we look at saying 20% of that is available to the orphan wells that we're going to be plugging, you're looking probably $20 to $30 million to plug that $1 billion hole. I'd like to move to slide 4, actually. So in slide 4, what I wanted to highlight is, one of the things we picked on, I believe it's slide 4. Yeah, so LFC, and it's towards the bottom of their statements, they're looking at roughly 2 barrels of oil equivalent as being kind of that break point for a well. I think there's testimony that at 1,000 barrels for a year, we're at 2.7 BOE. that's something else. I think holistically, we were expecting some feedback from operators based on their individual costs, their individual statistics, where they said, okay, we're productive at 1,000, but we're not productive at 750. And that's not something OCD got back from industry of where to draw that line, because that line could be picked somewhere else, but that's not something OCD got from industry. If that's 2 barrels of oil, personally, I think if the commission wanted to pick it at a 700 BOE, commission can pick it out at 700 BOE to be consistent with LFC. But that's what we were looking for when we picked 1,000. And I would state when we picked 1,000, we didn't know where LFC was going to land. And I will state between 2 barrels of oil per day and 2.7 barrels of oil per day, we're not that far off. Slide 5. This is the LFC chart of where wells are at when they get plugged. I don't have the data where they picked it. I'm just showing the graph that they provided. But as you can see, it looks like 2023, 2024, they're between the 600 and 700 BOE per year range. Before that, they were considerably higher. I will say as a regulator, sometimes when times are really good, plugging slows down because operators are divesting their capital into drilling, not plugging, because that's where the better bang for their buck for an operator is. And that's what I've been told in conversations with operators looking at enforcement in the past. So it's not necessarily wells are economical through there, because I think COVID was somewhere in there when the price of oil was extremely low. So I think if they weren't beneficial then, they probably weren't beneficial anywhere. But sometimes it's them divesting their capital into drilling and completion activity is where they're spending it, not plugging. So when we look at that, I think sometimes we say, well, that's where a well's beneficial. No, that's where an operator has to plug a well. Slide 6. So again, slide 6 covers what I showed before. On the bottom left, table 8 was the number of inactive wells by type. Again, this came out of the LFC report, but as you can see, they pulled it off our inactive well list, so I have no reason to question that. Again, 40% of the wells on that are on private land where only OCD regulates it, where 15% of the overall well count in the state is private. The top left, table 5, is your overall averages for well type pluggings that the OCD had. It looks like the LFC pulled this off a share. As you can see, the 150,000 that's in this rulemaking or in this bonding proposal, only injection wells are under that, and they're a far smaller number of wells that have been plugged of that type than any other. These are just real costs that we're seeing in the field when we're out there plugging. Let's see, let's go to slide 7, please. Slide 7 just highlights how old some of the inactive wells are. As you can see, there's 3 that are over 4 decades old. I think there's a large percentage that are even over a decade old. Again, this just highlights once it hits the inactive well list and hits our enforcement plate, it can be deficient for years, if not decades. Let's go to slide 9, please. So slide 9, again, just highlights. I'm not going to belabor this one. I think Rosa did a good job talking about overall costs. But I just want to highlight again, 66, I believe it's 66%. I don't want to quote this wrong. I don't have it handy. But a high number of the wells that we move on, I believe it's in my direct testimony, have leaks when we move on it. Slide 12, please. This is more of just what I talked about before, 750 barrels versus 1,000 barrels. This again is where we expected industry to bring more real numbers based on their experience, their cost data, which we don't have, to say this is a better threshold. We didn't get that, so we were left to our own devices, and we did the best we could. I will say between where we landed and where LFC landed is fairly close. Pulling the numbers, I would bet that you're probably within 10% of each other between those two numbers. And if the commission wanted to go with the LFC recommendation on that and go to 750 barrels, that would be up to the commission. Slide 16, please. So slide 16 shows what the LFC report recommended the OCD do now. As you can see, all three of those bullet points is promulgate rules. It goes through promulgating rules for low producing wells, promulgating rules for inactive wells, and also clarifying when transfers are contingency on regulatory approval. That's what this rule is doing, is following those LFC recommendations. I'm going to hit now slides 18 through 20, and I'll try to be as expedited as possible. What I'm going to show is some real examples. Again, these are different than what was shown by Lauren and shown by John as different costs for similar wells. Again, to show that well depth is not a very good indicator at all times to what it's going to cost to plug a well. Again, we're talking about wells that have been left to their own devices for years to continue to corrode or decay. These were also wells that LFC used as part of their demonstrations. Go ahead and go to the next slide, please. I'm not going to belabor what's in here. The commission can look at it, parties can look at it, but this is the plug-in plans that were proposed in both wells. As you can see, they're extremely similar in plug depths. Go ahead to the next slide. This is the subsequent plug-in reports. Again, I'm not going to talk exactly what happened in every one at every footage, just to save everybody some time. Next slide, please. I do want to point out between figure 12 and figure 13, some of the key differences between these two wells. Again, footages are very similar and drilled. These wells were drilled, I believe, within a year of each other by the same driller, by the same company, and I believe they're within a mile or a couple miles of each other. The well on the left, again, originally had 4 stages planned to plug that well, 4 cement stages. Because of at least 4 casing failures in the well, it was taking cement at each one of those plugs that was identified. So to plug 4 sets of, essentially 4 plugs, it took 9 cement stages to accomplish that coverage. The well on the right, things went well. So to cover those 4 stages, we pumped 5 stages of cement. The reason why it's 5 stages instead of 4 is because the length of the very first plug is over hundreds of feet, but it went according to plan. But as you look on this, the cost on the left well is $219,000 for OCD. The cost on the right well is $73,000 on wells that were planned to be almost identical. Next slide, please. Just some key notes here. Again, it's on record. I'm not going to belabor everything. The well on the left took 112 more sacks of cement to plug. When you look at overall coverage, once it was done, The well on the right actually had 104 feet more coverage when you looked at footage coverage when it was done, because it didn't drink as much cement. See, I think from there, can we go to exhibit? Let's actually go in order. Let's go to exhibit 30, please.
One moment, Mr. Powell. Madam Hearing Officer, can we have a time check on direct? I have 30 minutes. So, Mr. Powell, you moved much more expeditiously than I planned for your direct. If there's anything else you'd add, you have time remaining. Otherwise, of course, we can move on to your rebuttal.
No, I think in direct, I hit what I wanted to hit. Again, we expected a lot more feedback on the areas that I pointed out as we talked with industry. The only industry representatives that actually reached out were OCC. There's some things that we discussed with them. The May 1st was something we discussed with them. TA was actually another one we discussed with them and what scenarios. I'm sure I'm going to get crossed on that. What scenarios would it be beneficial to have something for over 8 years? I think there's some common ground on that. I'm sure I'm going to get questioned about that, and it's not in my direct testimony, so I don't want to opine here. But I think holistically, that's what we expected. We expected a lot more dialogue. Again, we don't have operators op costs for what it takes to plug a well or operate a well, those kind of things. And we actually expected more dialogue on that we didn't receive.
Right. With that, we're going to wrap up direct, summary of direct, and I will pull up the reference exhibit 30 and ask Mr. Powell to begin his summary of his rebuttal testimony.
Certainly. Again, all of this is on record, so I'm not going to try to belabor any of the points. So let's go to page 2, please. So I'm looking specifically on lines 1 through 8. Again, I just wanted to point out because in several of the direct, it again questions OCD numbers versus industry numbers. I'm not going to belabor all the points again. I think I've made my point clear that where OCD is plugging wells is vastly different than where industry is plugging wells. And if you look at industry's own data that they submitted for this rulemaking, there was a vast difference in between their own operators. Now I'll point out line 9 through 21. Again, I think there was some confusion on how many days were used, are the BOE, and then the 90 days. So 90 days, 90 BOE, 180 days, 1,000 BOE. It seemed obvious in reading the different testimonies that was the case. I believe there was a suggestion by Ms. Felix to remove the volume component, just go with the day component. So OCD is just making the statement, if one of those is to be removed, it should probably be the days, because this production days can be skewed just by having a valve open on a well that really doesn't produce. You can have a theoretical gas well out there, open a valve, and if it bubbles up every once in a while, it's producing. So if you're going to pick one or the other, you should pick volumes over days. I will say the original intent was captured by Welk's testimony in their scatter plot. It wasn't captured by OCD. I will also say that even through conversations with the applicant and internally as we were trying to set up that days versus volume, it was confusing, trying to get that language correct, as is evident in this case, in some of OCD's testimony. The 90 BOE and 90 days, because of that does that mean that those are looked at separately or together? You could also rephrase it as 90 BOE, which only produced less than 90 days, probably would have been a little clearer. But I will say, based on Welk's scatter plot, that was the original intent of what the OCD was trying to accomplish. with the 90 days is an operator should produce over 25% of the time. With the 180 days, an operator should produce over 50% of the time if they're being diligent in trying to produce that well. I think that's all I have on Exhibit 30. I would move into 31. So I'm going to high level. We're not going to go through all the statutes. I will say my slide's not quite as pretty as the rainbow slide. When we talk about the statute, I'm sure I'm going to be asked at length on that. The key points I'll point out when we discuss this one, there is a very clear distinction in that statute for the division, i.e. through the commission, to set categories when they're looking at it. The categories when we're looking at that have to meet certain thresholds in review. Because they have to meet those certain thresholds in review, the OCD can't just arbitrarily set them. They have to go through rulemaking, has to go through hearing, this process here. Let's go to the next slide, please. In this one, it talks about some of the things that the OCD has to do, such as consider depth of well. As I stated earlier, as OCD's talked about with their other witnesses, OCD did consider depth of well. In this scenario, we don't find depth of well as an accurate driver of what that well is going to cost, because there's a higher number of wells that don't match a good well when we get into it. It doesn't match the schematics when we get into it. It doesn't have wellbore integrity when we get into it. I'm sure I'm going to ask if I did an in-depth study of that. No, I haven't. That's based on my experience plugging wells, going through wells. I've been with the division roughly 19 and a half years now. I started working with orphan wells clear back when I was an environmental specialist, 2006 to 2011. I can't tell the exact year in between there. I've seen wells where we've had to pull rigs across the river onto an island to plug. I've seen where we've demolished a house because the well was in the middle of a house. There's always extreme examples. One of the things that was pointed out, the most recent extreme examples, I think Lauren pointed out, those were extreme examples we've seen in the last 2 years. We find extreme examples more often than we'd like to. I've had to dig down 19 feet just to find the casing because it corroded down to that point. It's not something that I don't expect to find. In Exhibit 16, one of the columns in that is the spud date of the well. I just looked this morning because I was interested after some of the discussions on age of well. The oldest producing well that I can find in that one, I believe, was 1926, that's still producing. We still have wells producing from the 50s, 60s, 70s, 80s, 90s, 2000s. All of that's in Exhibit 16. So depth of well, again, I don't think it's a driving factor. Length of time since the well was produced, well, we can't plan for how long it's going to sit there before it goes orphan. So that's really hard for us to kind of plan on. And it's something that we see as continuing degrading as we get to this end of life, what we called marginal, probably not the best choice of words. But these wells that are on the brink of potentially being plugged. And then other factors that well conservation deems relevant. I think we've given what we're paying for wells, what we're looking at. We use state procurement to set our plugging contracts. We're held by some of those costs. as far as who bids for what. Fortunately, unlike operators, if they don't like somebody's costs, we can't just move over and find another one without starting the procurement process all over again, which when we do that, if we were to stop what we currently have to elicit a whole new procurement process, you're probably looking 6 months to a year. High level, that's kind of where we're at. So we feel we've met the statute as far as what we have to show when we're proposing a new category underneath the statute. And I will say I'm not a legal expert, so when we start arguing law, that's probably not me. I can tell you we've used categories in the past before. I think the TA portion was in the rule. I believe that change may have been in 2018. We used it partially for the inactive wells. There was a category there where we assigned that because I don't remember if that was directly in the statute then or not. So it's something that we've continually used throughout its history. And I believe that's all I had on rebuttal, direct rebuttal.
All right. That concludes the summary of Mr. Powell's rebuttal testimony. I do have a couple questions on rebuttal, Madam Hearing Officer.
Thank you, Mr. Tremaine.
Mr. Powell, I'm going to read to you from the rebuttal testimony of Robert R. Scott, PhD. This is page 18. The lines are not numbered on this exhibit or this testimony. Mr. R. Scott, Dr. R. Scott indicated that from a practical standpoint, the proposed definition of a marginal well may be difficult to effectively implement. It is likely that operators already report the number of production days somewhat imprecisely. What is your response to this statement?
I would agree it's probably the correct. OCD does not enforce how many days an operator throws on their C-115 currently. I can tell you by looking at Exhibit 16, there's probably over 100 wells that they produce 10 BOE or less, and stated they produce for over 180 days. That's something, if we use both criterias, we're going to have to probably do more investigation into, more enforcement, more investigation to try to identify that, because it's not something we currently validate is how many days a well produced, because none of our current rules require us to.
On page 19, Dr. R. Scott also states, this raises the concern that manipulation of the forcing variable that the OCD would rely upon for implementation of the proposed rules would dilute the intended policy effect. It is also possible that bad actors might outright mislead the OCD regarding self-reported data, thereby avoiding the proposed regulation intended to address the moral hazard exploited by those same operators. How do you respond?
I think that's always at risk, and it's something that we use our investigative powers to pursue. If the commission wanted to set that at BOE, that's probably something that could be less likely skewed. It could be probably more verified with buyers if we go to refineries or we go to gas plants, we go to sales meters, because there's more third parties involved in that. It moves further away from our intent and what we were looking at doing. I believe we also ran some new numbers as far as what we were looking at. If we just went to BOE, it would encompass more wells, honestly, but operators could then bring, as part of their presumption of beneficial use, data showing where they're trying to produce that well. But it would be more verifiable data than just having them put days in their report.
Mr. Powell, I'm going to ask you to respond to the rebuttal testimony of Clay Paget. On page 2, line 6, beginning, Mr. Paget indicates the New Mexico wells in Hillcorp's portfolio that produce less than 1,000 barrels of oil per year produce on average a combined 19,350 MCF of gas per day and approximately 370 barrels of oil per day. Subject to the prices of varying royalty rates, this amounts to between 1 million and 3 million of revenue to the state of New Mexico per year. Wells producing 1,000 barrels of oil equivalent or less per year represent an immense amount of production for the state of New Mexico and ensure that the state's resources are not wasted by premature plugging. How do you respond?
I think that's really evident in looking at some of the confusion over the definition of marginal well or inactive with the days. My guess is Hillcorp's probably producing those over those thresholds. So again, as long as they're producing them over 180 days, they wouldn't fall into that threshold as currently written.
We've heard substantial questions and testimony about the and/or question. In Hillcorp's testimony, as I indicated here, did they utilize the day component in preparing their testimony?
No, they did not.
Further, on line 17 of the same page 2, Mr. Padgett indicates, since it began working on reducing the methane emissions from its San Juan Basin assets, Hillcorp has reduced such emissions by over 90%. How do you respond?
Not looking at their emissions completely, I can't validate that. I do know we've worked with Hillcorp in the past to try to make sure that their emissions are accurately calculated. I will also say Hillcorp has a robust recomplete program to bring up the production levels of their wells, and they've been successful in that process. Again, if you use the day component that Hillcorp didn't use and you produce over the 180 days, it doesn't fall into that marginal criteria. And so they can continue with their recomplete schedule. They can continue with those operations, and it's not likely to cost them as much. I would also state Hillcorp has, and I don't know what it is today, but I know it's over 12,000 wells in the state. So they're looking at, so when you're talking those numbers, that's something that should be shown as far as the size of Hillcorp and what they're looking at doing.
Further, on page 4 of Mr. Padgett's testimony, line 8 indicates that the proposed rulemaking would disincentivize operators like Hillcorp who are responsibly enhancing production from low-producing wells. How do you respond?
I would respond as I just did. They are increasing production. They are recompleting wells. As long as they're operating their other wells above 180 days a year, they're probably not going to be affected much.
All right, Mr. Powell, I'm moving on to refer you to the rebuttal testimony of Mike Cantrell. On page 4, line 1, Mr. Cantrell begins, so New Mexico needs there to be a stripper well industry in place to continue the life of these wells from that time to their economic end. The proposed rules endanger not only New Mexico's economy today, but the economy from oil and gas in New Mexico's future by ignoring alternate possibilities and advances. How do you respond to Mr. Cantrell's statement?
So I would respond by saying what we're looking at today is significantly different than stripper wells. Stripper wells in New Mexico are wells that are at 10 BOE per day. It's not 10 BOE for 90 days. It's 10 BOE per day for a year. So we're looking at something that's considerably less than that. I think the marginal well, again, don't really care for the phrasing after hearing this testimony before me, but taking that, we're at 2.7 BOE per day. So we're at 27% of what a stripper well is. At the 90 BOE, I think it's less than, or at 90 BOE for the year, I believe it's less than 1 BOE per day. So it's less than 10% of what a stripper well is. We agree we're not trying to get rid of stripper wells. The state of New Mexico has looked at incentives for that. There are some things, if price of oil fall below a certain percentage, they need help to be economical. We're not looking at using the stripper well thresholds in this. We're actually far below those thresholds.
Mr. Cantrell then goes on to say, second, Welk's proposal mimics Colorado's efforts to eliminate small producers through unsustainable financial assurance levels enacted in 2022 after the Colorado legislature passed SB 19-1 181. How do you respond?
First off, I don't know Colorado's rules, haven't reviewed them. I will state that, and I'll show here shortly, an example of a really good small operator of what we're looking at seeing. Again, we're looking as written today with the days incorporated. As long as an operator is producing their well, they don't have to post the bonding. If they have 181 days, this rule of production, this rule will have no effect on them as far as bonding.
Madam Hearing Officer, I have a couple rebuttal questions for Mr. Powell related to Mr. Winchester's rebuttal testimony. Mr. Powell has recently prepared two demonstratives similar to Mr. Cloutier's presentation earlier. He's cooking right along, so I didn't send that email out to everyone yet. So I'd like to put those up on the screen and then proffer them through email for everyone's review after. That's all right.
Thank you.
All right, Mr. Powell, I refer you to Mr. Winchester's rebuttal testimony, page one.
Madam Hearing Officer, one point with Mr. Tremaine. I really don't mind rebuttal demonstratives, but I got objected to yesterday for them. I want to make sure sauce for the goose is sauce for the gander. Again, I don't want to be dealing with objections if my witnesses have a couple of rebuttal exhibits.
All right,
So,
we're all doing the best we can, I think.
Yeah, I do respect that. I believe that was one of my few objections that have been overruled. And we will, I'm happy to share them. They are qualitatively quite different. One is response to the total number of wells. They're simple numbers. We're not talking about the baiting complex.
So let me ask you, we will need a break before the 4:00 public comment. I'm wondering if it would help right now to take a break so that folks can look at it and then come back.
Quite all right. I thought we were going to go longer and that I was going to distribute these on a break. So I'm happy to do that for everyone's benefit.
Great. Let's come back at about 10:04. From the break, please. We have ended the taking of technical evidence for the day, for the week. We're going to pick up again with the conclusion of Mr. Powell's testimony Monday morning after the 9 o'clock public comment session. So the only other thing we're doing today is a 4 o'clock public comment session. It is 4. I have the names of 3 folks I'll be calling on, and then I'll ask if there's anyone else on the platform. Just a few things. I will ask you to state and spell your first and last name. I will ask you to swear or affirm to tell the truth. I will ask you to keep your comments to 3 minutes. In the event you'd like to say more, please submit written comment anytime over the next week to Sheila Apodaca, the Commission Administrator. So, Sheila, who are we going to start with? Charles Goodmacher. Mr. Goodmacher, can you unmute yourself?
I am unmuted. Can you hear me?
Yes, thank you very much. Would you please spell your first and last name?
I certainly will. Charles, Charles, Goodmacher, Goodmacher. And what am I swearing to again?
You're swearing or affirming to tell the truth.
Yes, thank you.
All right.
I so swear.
I'll start your time.
Thank you. I lived in Roswell for nearly 5 years of my life, during which time I traveled throughout the Southeast region every week. There are plenty of smelly, ugly, and dangerous abandoned wells throughout the region. You know this. These abandoned wells don't just create financial risk, they're dangerous. The methane and toxins leak into the air in our groundwater, harming wildlife and public health, especially rural and tribal communities. Industry pollution, including from abandoned wells, increases our state's healthcare costs when our people become ill from the contaminants. The industry, meanwhile, spends huge sums of money throughout the year to tell us they are our neighbors, and so they too are working towards a clean environment. Well, their opposition to simply ensuring the bad actors in their industry post sufficient bonds to cover the cost of their cleanup says otherwise. Please, on behalf of our children, please pass the rule as proposed. Thank you very much.
Thank you very much, Mr. Goodmacher. Let's see, do we have Karen Bowler? Or, oh, it's Kenneth Brennan. Mr. Brennan? Can you unmute yourself?
There we go. Can you hear me?
Yes, now I can. Would you spell
Okay.
your first and last name, please?
First name Kenneth, Kenneth. Last name Brennan, Brennan.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Hello. As I already said, my name is Kenneth Brennan, and I've lived here in Edgewood, New Mexico for the past 16 years. My family moved to New Mexico in 1975 from Massachusetts. I am a retired U.S. Navy gas turbine chief petty officer, a retired GE wind field manager, and I am currently the mayor of Edgewood, New Mexico. As mayor, I serve on the North Central Regional Transportation Division, the Mid-Region Transportation Planning Organization, where I currently serve as the board chair, and the Workforce Connection of Central New Mexico. New Mexico has been home to my family since 1975. I graduated Cibolo High School, class of 79. Coming of age in New Mexico, I explored many areas of this state and enjoyed its diverse culture and recreational opportunities. Moving back home after retiring from the Navy, I have come to appreciate New Mexico's diverse energy portfolio. As a manager in the wind industry, a traveling technician in the industrial gas turbine power division, and as a propulsion engineer in the Navy, I have a unique understanding of the energy field. New Mexico's vast oil and gas industry is not only the economic engine that supports our great state, but it is one of the largest employers in the state, a major contributor in funding our education system, and proof that large and small companies can work side by side. Small companies are the backbone of our nation and state. This also applies to the mom and pop oil and gas companies. We need to support these entrepreneurs of the oil and gas industry and not make it more difficult to operate and in turn support our state. Hurting them will only hurt New Mexico as a whole. Even though Edgewood is not directly connected to the oil and gas industry, what happens in this industry affects the citizens of my town through lower funding of education, higher taxes to make up for lost oil and gas revenues, and the strain on our unemployment compensation funds. We need to stop putting up barriers to our bread and butter and work on ways to support them. I therefore ask you to consider what I have said and the important role oil and gas industry plays in our state when making your decision. I humbly thank you for your time.
Thank you very much, Mr. Brannan. Let's see, I think we have Leo Lemerceau. Can you unmute yourself?
Yes.
Hello. Would you
Hi, how
spell
are you?
Good. Would you spell your first and last name, please?
It's Leo. Last name is Lermuseaux.
Thank you. Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Hello, everyone. My name is Leo Lermuseaux. My family has proudly called New Mexico home since 1904. Education has been a cornerstone throughout my family's history, with my parents, grandparents, and wife all dedicating their careers to the education sector. My grandfather taught vocational mechanics, while my grandmother served as a bus driver for the Bernalillo School District until their retirements. My father also retired from Bernalillo School District, where he worked as a transportation director. Additionally, my wife retired from Rio Rancho Public Schools, where she was a special education teacher. For the past 42 years, I have devoted my professional life to the power industry, working with P&M at both the San Juan Generating Station and the Reeves Generating Station in Albuquerque. Through these experiences, I have seen firsthand the benefits of affordable, clean energy available to residents of New Mexico. The oil and gas industry, along with the many supporting businesses that serve this sector, provide some of the highest paying jobs in the state. It is essential to ensure that residents have access to low cost energy, as the introduction of strict regulations would affect every person living here. As a state, it is vital that we continue to work diligently to keep energy costs as low as possible, since this directly helps lower the prices of all goods, including groceries, gasoline, and everyday essentials. Moreover, the financial backing for our state's education system would face significant challenges if the oil and gas industry were forced to leave New Mexico. I encourage you to thoughtfully consider the many lives and communities that would be impacted if this critical industry were driven out, given its essential role in supporting our economy, education, and public services. Thank you for taking the time to listen to my comments.
Thank you very much, Mr. Lemerceau. Let's see, there was Karen Bowler. Ms. Bowler, are you on the platform?
I don't see her on here.
Oh, okay. Is there anyone else who would like to offer comment during this public comment session? Our next public comment sessions are on Monday at 9 a.m. and at 4 p.m. The comment session on Monday at 4 p.m., there will be a Spanish language interpreter available. Anything else? No? All right. Thank you all very much and have a great weekend.